Dear students, let us start the discussion on 26th March 2016 newspaper. Now, let us discuss about privacy and Aadhaar, how they are connected with each other. There are two important questions which are posed over here. One is constitutional propriety of the Article 113 of the Aadhaar under Article 110 of the Constitution. Now, Article 110, it explains about the money bill. So, in this case, 110 subclause 3 says that the Speaker is the final authority to decide a bill is a money bill or not. So, what is generally expected is the Speaker takes interpretation of the Article 110 in defining the money bill. So, if the government resorts to making every bill as a money bill, probably it leads to the condition where the Rajya Sabha becomes irrelevant. So, this is what is the constitutional dimension of the bill. The next is related to privacy. Now, the security of the state under this, executive can access the information under UID, Authority of India. So, it means there is a blanket opening is given to the executive, that is bureaucracy, to access the personal information of the citizens. And the third thing, private sector and public sector are also. The government, why can't we give the information to the state when we are giving it to the private sector? This is the constant question which is posed. If you are giving the information to Google, then it's a private entity, and it does not mean you also need to give the information to the state. The argument goes in regulation of the private sector rather than giving more powers to the state. The second is, the state has a coercive element. It can use power. So it can cause arbitrary arrest. So the information can add up to the power of the state. So in this case, the argument says that the private sector has to be more strongly dealt with regard to the private information of the citizens of a country. So this is about privacy argument with regard to Aadhaar is concerned. The real estate and non-rescue, what is this bill is? You know that the real estate regulation bill is passed by the Parliament. So in this real estate regulation act, there are few important things. Does over-regulation leads to better protection, or is this an appropriate regulation? So the first argument where it just fits in, if you take the states versus markets. So the markets, open market, a vibrant and dynamic market can provide for better services to the people is the argument. So regulations and regulatory authorities cannot be a substitute for vibrant and dynamic market. So anywhere the regulation leads to increased corruption, increased litigation, and then unregulated growth may keep many of the people getting advantage from the land and also from the housing being a basic requirement. It also deprives them of this basic necessity. Both sides of the argument are there. What the author argues is, the first one is, the litigation is going to increase because the rules which are not being followed ultimately increases the number of court cases, and this litigation is going to deprive of this. And many of the old buildings are traded, sold and bought, but this bill only covers the new market products which are coming up, the new apartments that are coming up. And over-regulation, now no objection certificate when it is been not given by the municipal authorities for corruption or some other reason. There is no accountability under the bill. So in this case, this is providing for a regulation and without the accountability on the bureaucracy to deliver the service within time. So it may be ineffective. Now this is the most important article with regard to conflict of interest. So a businessman sitting in the parliament, he shall work to the public policy rather than to his business interests. So in this case, the model code of conduct, what it says is, any minister has to sever his relationships with any business before or within 2 months he enters into the office. Across the world, there are clear guidelines in this matter. That is Canada's Conflict of Interest Act, United States Basic Criminal Conflict of Interest Statute, is basically to keep the people away from their away from their private interests while in the public office. So, existence of conflict of interest can undermine the confidence of the people in the government of the day. So, that's the reason why in India, either it is an MP or a minister, shall give declaration of his private interests. And if he is a minister, he shall not function within the private interests, or else totally he shall be disconnected from his private interests. So, these are the three important articles for today from Indian Express. Now coming to a lesson in hidden agendas. Again, this is also a state versus market debate. So, with regard to Right to Education Act, do we need to go for the private education or to the government-sponsored public education? So, this is what is the controversy. Recently in Rajasthan, low-cost private education schools, they raised a voice saying that Governmental Right to Education Act is promoting the public sector or public sector schools, and they are asking for undue demands to maintain the infrastructure in their schools and closing them down. So they say that the quality of education and other parameters, cost of education, they are better with low cost private schools when compared to the public schools. So they recommend a marketization of education, where instead of providing for schools, the government what it has to do is give the coupons to every family, and they can go to any private school and the coupon will have a currency value when the private school can redeem that particular coupon. This is what is proposed. Now in this case, what is the empirical proof says that? So one is access versus quality. So the quality is good at low cost private schools, that is what is people are saying. Now with regard to access, the private schools are not providing for the equal access to all the people. Especially the lower caste, they don't have proper access to these schools. So is this only the financial limitation which is not bringing them to the private schools? Are there any social limitations too? For sure in India there are many social limitations. And then we say the private school is better based on the quantification. That is, per unit cost of learning outcomes. This is what is the calculation which says that private education is better. So in this context, it is not always possible to quantify the education. So the objective of quantifying the education and its attainment itself is wrong. And added to that, private sector's major objective is to make the profit. And on the other hand, the public sectors is about welfare. And added to that, to make more profits, they maintain low salary teachers and also grossly inadequate infrastructure. So in this context, to what extent public or private they can serve who can serve the better public interest we can understand. Now regulation. A right to education, they prescribe certain standard norms a school has to follow. So regulating the market or regulating the standards in essential services such as health and education is the responsibility of the state. Marketization of education. So if you observe the Amartya Sen statement, the marketization of education did not achieve the universal education across the world. So in this context, the real challenge before us is the implementation of the Right to Education Act rather than anything else. And then electrified villages. You know that Deen Dayal Upadhyaya Gram Jyoti Yojana. So it aims to connect or electrify all the villages. So what is the procedure prescribed under this? Now to increase the participation of the citizens and for information sharing, a mechanism was created. One is a mobile application, that is Garv exists. Under this, a Gram Vidyut Abhyantas. These people will regularly update the status on the electrification of the village. So based on that, government will take the inputs on how many villages are electrified and present it to the parliament and for various policy exercises. So this is very important aspect to me, because how the government is taking the ground information and how it is trying to reach to the people, that is very necessary for us. So here the major challenge is the information given by the GVA is not regularly updated with GARV, that is leading to something called as improper or asymmetry of information. So that has to be rectified. Coming to the WTO issue, previously I have discussed this solar panels issue. So, in brief, what is this? Government of India has said that the solar panel production or domestic product requirement is one thing which the government of India specified under Make in India, that anyone who establishes the solar market or solar panels, so they have to procure certain percentage of the solar panels from Indian market. So this is challenged by the United States as against to the fair trade rules under WTO, and the WTO judgment came in support of the United States. So in this context, India wants to challenge that judgment in the court of law. So this is what we discussed about. Thank you very much. All the best.